Hello, everyone. We're going to give everyone about a couple minutes to join, and we will start right after that, so stay tuned.
Okay, I think we have a critical mass of rather large audience actually to begin. Good afternoon, everybody. My name is Moshe Bain. I'm the president of the Orthodox Union, and I want to thank you all for joining this afternoon's talk to hear about one of the very critical issues that's currently pending in front of the Supreme Court that has a potentially very significant impact for the Orthodox Jewish community and for America at large and its culture and its attitudes. The OU Advocacy Center, which is the public policy arm of the Orthodox Union, has been spending decades fighting for Jewish day schools and religious freedom. Today's briefing focuses on the consequential United States Supreme Court case, which puts in jeopardy the future of a government funding of religious schools, which is obviously of incredible importance to our community and the centrality that Jewish education plays in our lifestyle and in our value system. Those hearings began this morning. Today's briefing will be conducted by two very good friends of mine who are actually leading warriors on behalf of the community's efforts to ensure religious freedom. First, Nathan Diamond, who is the Orthodox Union's Executive Director for Public Policy, and a very good friend of the OU and a very important advocate for the community's interests, Professor Avi Helfand, who's Vice President, Vice Dean at Pepperdine Law School and currently a visiting professor at Yale Law School. The OU Advocacy Center, together with Professor Helfand and with the support of the Sidley Austin law firm, wrote and filed an amicus brief, a friend of the court brief, in this very important Supreme Court case, arguing strenuously for the continued funding of Jewish day schools, yeshivas, and other religious schools. I'd like to introduce for this afternoon's talk, Dan Mitzner, who's the COO of the Orthodox Union's Teach Coalition, who's going to be moderating today's events. Dan?
Thank you, Moish, and thank you everyone for joining us today. We're really excited to have so many of you with us to have a very timely discussion. We are here today, particularly today, because the Carson versus Macon case, which we're going to be discussing ad nauseum, had oral arguments heard today, and so there's actually quite a lot for us to go over and to fill you in on, and to just kind of give you sort of the lay of the land and what this actually means and the implications, the broader implications for what this means for yeshivas and day schools around the country. So I guess without further ado, why don't we just jump into the general overview. Avi, if you can, just walk us through what this case is actually about.
So here's the thumbnail sketch of 50 years of Supreme Court jurisprudence with respect to the funding of religious institutions and religious schools. Here are the two big questions. When can government fund religious institutions? And when must government fund religious institutions? Back in the day, 60s, 70s, the answer to the question of when can government fund religious institutions was pretty much never, or almost never. And this was the no aid period of the Supreme Court, which largely changed in the 80s, 90s, and really in 2002. 2002, the Supreme Court hears an opinion about a school voucher case, and the Supreme Court, for the first time, has a majority where the majority says, actually the state of Ohio can have a school voucher program where there will be funding going to religious institutions. Of course, the fact that the government or state governments can fund religious institutions doesn't mean that they must fund religious institutions. In fact, in 2004, just 2 years later, the Supreme Court dealt with a scholarship case out of Washington State. This is a famous case, Locke v. Davie, where the Supreme Court says, even though you have this funding program available generally, lots of people can get scholarships, the state of Washington, even though they can provide that kind of scholarship to a religious institution, they don't have to. They can exclude religious institutions. In that case, it was about they could exclude scholarships going to degrees in devotional theology, training ministers. And so back in over 2004, where things stood was states can provide funding, but they don't have to provide funding. That changed pretty much in 2017. Supreme Court now hears a case in 2017. These were grant programs that was going to grant that was going to go to a playground owned by a church. And here you had this funding program where the state of Missouri said, because the playground is owned by a religious institution, this state of Missouri said, we're not going to provide that funding. We're going to exclude religion. And in 2017, the Supreme Court says that is prohibited religious discrimination. Once you have a funding program open and available to private institutions, you can't exclude religion. Now, this presented a puzzle, the puzzle that kind of takes us to today. In 2017, you couldn't exclude religion. In 2004, it sounded like you could exclude religion. You know, how do we justify the distinction? And one way in which some justices seem to justify the distinction was as follows. In 2004, it wasn't about the religious status of the individual seeking the scholarship. It was how he was going to use the money. And so states can exclude religious uses of funding. But in 2017, the state of Missouri said, we're not going to provide funding to any religious institution. It was based on their status. And so here we had, coming to today's oral argument, we had a distinction lurking in the background. You can discriminate on the basis of religious status. Everyone can get the funding, except institutions that are actually religious. Religious institutions you cannot discriminate against based on their pure status. However, if you have circumstances where funding is going to be used for religion, then states could say, we don't want to give funding for religious uses, even though everybody else is going to get funding. Does this status use distinction still hold up? And that was what today's oral argument, at least that's what we thought it was going to be about. Religious status, you cannot discriminate against. Religious use, you can. And that's what we thought we'd hear this morning. This morning, actually, everybody's wanted to stay away from this status use distinction. And it's not surprising. It's super bizarre. The status use distinction is weird because you can almost always describe something that's a religious use as religious status as a religious use. As the Supreme Court once famously said, you know, discrimination against yarmulke wearers is discrimination against Jews. You know, we understand that status and use are interchangeable. This morning, the Supreme Court and both parties really ended up staying away from the distinction, which raises the following question. Is the Supreme Court finally going to be in a position to say all forms of religious discrimination when it comes to funding, whether it's based on religious status or religious use, are constitutionally prohibited? That's what we're looking at the end of this morning, and kind of the briefing that we did, myself and Nathan and the Sidley Austin team are hopeful that we'll finally get a clear statement on this issue from the Supreme Court.
And just, there was one thing that I forgot to say at the top. We're going to be taking questions and answers at the end. So if you do have questions, please just type them in the chat and we will be able to see them, and we'll try to answer as many questions as we can. So Nathan, why don't we talk about, you know, maybe a little bit of a deeper analysis here, and what are some of the real potential outcomes that we could see for this case?
Yeah, thank you. You know, one thing that did come up, one thing I would say about the arguments this morning was the discussion amongst the justices and between the parties was very focused on the school context. And while there were a few questions here and there that opened the door towards broader, situations in which the government might fund religious institutions for other purposes, it was very, very focused on schools and education and curricula and things like that. And part of that, I think, was driven by particularly someone like Justice Breyer, who in his questioning kept talking about, what are the, is it going to be a danger that the state is seen as funding one, a particular religious approach, and it might be a religion, that has, he didn't use the term, but like might have politically incorrect views, and is that going to be divisive, and so on and so forth. On the other side, you had a couple of the justices on the more conservative end of the bench, like Justice Kavanaugh, for example, who said, well, isn't it divisive if you have two families living on a street in Maine, in rural Maine, and one of them is able to send their child to, with government funding, to a private school because it's a secular private school, and the one next door is not able to send their child to a private school because it's a religious private school? Isn't that divisive? Isn't that going to cause strife? But they very much focused on the school context. And the school context, this case does potentially have implications for a lot of the advocacy work that we do at the OU, at the federal level, and also through the Teach Coalition. A live issue right now that we're advocating on in the legislative arena is, Congress is working on this massive new social welfare bill, the Build Back Better bill. And one piece of that we are very focused on is the proposal to have a federally funded universal pre-kindergarten program. And that's going to be unlike the program in Maine or the program in Washington State that Avi referenced earlier, where the money goes to the parent and then the parent directs it to a school. This will actually be a direct funding program that goes from the government to the school, right? The schools that would be providing the pre-K classes. And so you would potentially have a question of, okay, let's say your yeshiva or day school wants to have a government funded pre-K program. Aside from many, many questions, one question would be, well, could you have religious content in that program, right? Could you this month teach about Hanukkah and sing Hanukkah songs with the pre-K kids? And traditionally, even recently, the constitutional view has been you can't really do religious activity, core religious activity in a government-funded program. If this case, even if the legislation that comes out of Congress, if it passes and if it says, here's a direct funding program and ostensibly you could not have religious content, if the court issues an opinion in this case which says you can't discriminate in an otherwise generally available government funding program with regard to religious use, not only status, right, then that will mean, no matter what this legislation says, that the Jewish day school will be able to have religious content if they otherwise qualify to be a pre-K provider. In a very different context, I'll do for a moment what the justices did not do and talk about things outside of the school context, right, that might be relevant to shuls or other religious institutions as well. So, we spearheaded the creation of the Nonprofit Security Grant Program, under which the Department of Homeland Security gives money to shuls and schools and other kinds of religious institutions to make their buildings safer. That's never been challenged in court as a violation of the Constitution, which is a good thing. But theoretically, it could be, and you could say, wait a second, you're providing money to the infrastructure of a synagogue, and what happens in a synagogue? Religious activity. People are praying. People are studying religious teachings, and this is government subsidizing religious use. If this case is resolved as we have advocated for it to be, then that will be a settled constitutional question, because it would not be a constitutional challenge to say, again, the government has a neutral purpose. The government's not giving the security money for the purpose of advancing religious activity, right? It's giving the money to keep people safe. And so this ruling hopefully will stand for the proposition that if the government is giving the money to keep people safe, it doesn't matter constitutionally that what they're doing in that building is religious activity. So those are two examples of where what we're hoping will be solidified with hopefully a broad ruling in this case.
And I'm going to be a little bit selfish here, Nathan, as the representative from Teach Coalition and our state level advocacy. Could you also talk or translate this into how this would impact some of the state programs that we work on and what that means for yeshivas and day schools?
Sure. So again, there too, if we take the New York the paradigmatic New York program as an example, where Teach has successfully advocated for the state funding STEM teachers at non-public schools, including religious schools, right? So right now we've set that up, particularly for the state. The state says we want high quality math and science education throughout the state of New York. We do that in the public school system, and we're going to help the non-public schools by making sure they have high quality math and science teachers. And the Teach team advocated for that because math and science are kind of perceived as non-ideological topics that generally you don't get into fraught issues that might involve religion and these kinds of constitutional issues. But again, this theoretically, first of all, it could be challenged as money is fungible and you're subsidizing, even though you're really only subsidizing the math and science teachers, that frees up money for the day school to spend more on Gemara and Chumash teachers. That would be one argument. So this would solidify that. But then also looking forward, it would again enable us to potentially advocate in Albany to say, okay, you don't have to only fund math and science teachers. You could certainly fund English and history teachers, even if we're going to teach history from a perspective of, maybe we're going to teach Middle East history, and some of that Middle East history is going to be informed by, in some schools, right, a religious perspective with regard to, the Jews being in Israel and so on and so forth. That would be on constitutionally more solid ground, again, depending on how this ruling comes out, than where we are right now, being a little bit more reticent to push in that direction.
Sure. Avi, did you want to jump in here as well?
Yeah, I just practically, I want to think about what it is advocacy in the funding area is trying to do. The core of it is there are a variety of circumstances where federal and state government says, here's the thing that's really important to us: security, schools, whatever it might be. And we'd like to fund private institutions that help accomplish that goal. And the big question is, can states or can certain localities say, yeah, we're going to do that generally, but for religion, we're going to exclude it. We're not going to do it. In 2017, they said you can't say because you're a religious institution, you get excluded. But the question is, you can always change that. Government can easily say, we're not excluding you because of who you are, but it's because of what you do that we're going to exclude you. This is a problem for, I would say, Jewish schools in particular, especially, I would say, modern Orthodox day schools that are particularly committed to an integrated curriculum, where we aspire, where we really hold up the idea that, all parts of our curriculum are intended to accomplish a religious goal. This great kind of, theological benefit becomes a legal issue, because, if you really claim everything you're doing is religious, what about your art teacher? What about your music teacher? Could states really come in and say, yeah, we're going to provide all this great funding to schools, but because you're using it for something religious, we're going to exclude you. And, that's why the advocacy here is so important. You want to clear the deck and say, listen, you can't exclude religion. I don't care if you want to call it status or use or whatever kind of distinctions you want to draw. The bottom line is, the First Amendment prohibits excluding religion from government funding. That's the goal of the advocacy in this area, not to leave a distinction on the table where states can hide what I would say are discriminatory practices when it comes to religious funding. So kind of as both Dan and Nathan expressed, Teach Coalition has done, incredible things when it comes to STEM. Is the next step, music teachers, art teachers. You can see where schools might want to go. These are important programs from the perspective of the state. You can see why a state might want to say, yes, we'd like to provide that funding for both public, and we'd like to also extend it to private schools. And when you get great things like that, do we have to worry that, oh, but because our music teachers sing religious songs, or because our art teachers do projects for the Chagim, that all of a sudden a state can say that, well, that's religious use, so you don't get included in this government program that's meant to, help schools and kids and families, across the state. I'd say that's kind of the core of what this is. And hopefully you can see if there's no distinction on the table, there's nowhere for government to hide these kinds of discriminatory exclusions.
Absolutely. And so, something that we always talk about at Teach is our goal of trying to fully fund secular education. And so this is something, should this case be decided the way that we're hoping it does, this really, as Avi and Nathan have pointed out, could clear the deck for that reality to come into play. So that's.
I'm gonna insert a caveat, which is it's gonna put more weight and more need on the advocacy piece. And what I mean by that is, as Avi recapped, right? The Supreme Court said all the way back in 2002 that school voucher programs are constitutional. That did not mean that all of a sudden, right, we have school voucher programs, all across the country. That made it permissible. That meant that the ACLU or somebody else couldn't go into court and get a court to block a school voucher program claiming it was unconstitutional. It took it out of the realm of litigation, basically, and put it into the world of advocating to the legislatures, advocating to your governors, mayors, what have you, et cetera, et cetera. And so this case potentially does the same thing to a large degree, right? It doesn't say to the state of Maine or Maryland or New York or wherever, thou shalt create a program that provides funding and services to non-public schools. The state could say, the only place we spend money is the public school system. The state could say, we do not spend any money on non-public institutions, secular, religious, we don't care. And that would be perfectly legitimate under, the most expansive version of what the court might do in this case, or that it's done in the previous cases. It's not taking, policy-making decisions out of the hands of the political branches of government. What it would be doing is settling the constitutional question and making it all the more important that the grassroots, grass tops, leaders of the OU and all the school communities, et cetera, really engage in advocacy to try to expand the kinds of support that we are seeking.
Exactly. So we are talking now more or less about best case scenarios if the court does decide this case in the most, as you mentioned, Nathan, the most expansive way. And I know you both touched on this a little bit before, but just to maybe put a finer point on it, and also, I guess, set potential expectations, right? And for those who aren't really familiar with how the Supreme Court works and how it could actually decide cases, could you explain some of the potential outcomes here, what we could actually be looking at, so that everyone has a deeper understanding of that?
Sure. Oh, sure. So, you can just think about the potential buckets here. Option one is we get this opinion that says you can't, excluding religion for whatever reason is problematic, and therefore once you have a funding program available, it has to be available to all comers, including religious institutions. Option two is the court goes the other way and says, no, we still think states have the ability to exclude religious use. And if it does something like that, which I would find surprising, candidly, but it's possible. And then you'd be in a circumstance where we're constantly trying to divide, between, what fits into which bucket. The third option, I would say, even maybe the more interesting option is kind of like that 2004 case that I mentioned, where the Supreme Court said we can exclude circumstances where, like, you have funding going to prepare somebody for the ministry, a degree in devotional theology. The Supreme Court might say, yeah, that's still good law. The state can say we're not going to give money for that, but all the other stuff, all the other forms of discrimination, that's no good. And then we'd be in like a super strange place. And this is where litigation would head going forward. You'd have religious, you can't discriminate on the basis of religious status. you can't discriminate on the basis of religious use. But you could say, as a state, we don't want to provide funding, as I like to refer to it, as minister stuff. People don't know what's in that bucket, but you can imagine like the next round of litigation, states trying to show how some states trying to show, yeah, this is a little too close to minister stuff. You have a teacher that's kind of like a minister, and you can see where litigation might head under those circumstances. So I would say those are kind of the buckets in play. The more expansive, never discriminate against religion, sometimes discriminate against religion, and then this kind of peculiar middle ground, which we might get. Or, alternatively, the Supreme Court might just give us like a super inscrutable, narrow decision about schools that we can't decipher. And then litigation will also continue apace.
I would just add, I think there's one other path that might, it might clarify or it might make things more muddy. There was a lot of time spent this morning, particularly because the lawyers representing the plaintiffs were from the Institute for Justice, which is a school choice oriented advocacy group. There was a lot of reliance on the fact that this is not a direct funding program from the government to the schools. It's still, the money goes to the parents, and the parents are directing where the money goes. So, theoretically, you could also end up with an opinion that says, well, we don't have to really, talk about direct government funding. We don't have to resolve our problems like with the Trinity Lutheran case, which was the church playground case, because that was money that went to the church. And they had to figure out like, okay, we're going to let them get the money to make the playground safer, but we're not yet reaching the question about, suppose they wanted to do something to the church itself that would support religious activity and so on and so forth. They could avoid the question of, are we going to say it's unconstitutional to not give money to a religious institution for religious use by saying this case still has the safety measure of it, there being, independent choices by the parents, which disconnects it from direct government funding to religious activity. That could be a little wrinkle in this also.
Right.
Dan, did you want me to jump in on?
Yeah, please. Please.
Yeah, there's one thing
you
that Dan and I have been chatting about, and also Nathan. When I originally approached Nathan about all this, a lot of discussion here, and for obvious reasons, is on the practical side. Kind of what does this case mean for Jewish institutions? When we talk about mean, what we're talking about is kind of in terms of our ability to secure funding and how that offsets significant costs that members of our community have to otherwise absorb. I was particularly passionate about this case because I also think that there's a really important values piece to all of this, and our brief. I think really captured that. I recommend giving it a read if you have some time. And the goal of, I think, Orthodox Jewish advocacy in this arena, and why I'm always so proud to work with Nathan and the OU on these kinds of initiatives, is because excluding religion based on the use of it, it's not just what the implications are for us, but it really, in a certain way, privileges let's say certain forms of theology above and beyond the way in which Orthodox Jews practice religion. And here's what I mean by that. What I mean by that is, the idea that you can exclude religious use is so anathema, I would say, to Orthodox Jews, because the way we live our lives, everything is governed by Jewish law in some way or another. Halachic Jews, it really covers just about every part of the human condition. And as a result, there's lots of things that the world views as secular that we view as religious. I joke all the time. I'm doing construction on my house, and I built a ma'akeh, a fence around it, and I made a bracha. And I made a bracha on something that, in secular law is just simply the idea of like following health and safety codes. You have to have a fence around it. But for us, that's something religious. The idea that you could exclude on the basis of religious status, but not religious use, really runs counter to the way in which we live our lives, that everything we use is religious. And so it tilts the scales in favor of certain majoritarian faiths. And I'd say, leaves us with the short end of the stick. And so advocacy in this particular space isn't just about the dollars, although that would be good enough reason alone to engage in this advocacy, but it's also asking the Supreme Court to recognize that constitutional distinctions have to put all faiths on the same level playing field, and that American Jews should have a same seat at the table as every other American citizen. You know, when advocacy does both of those things, both advances the interests of the Orthodox Jewish community and expresses the value of our participation in civil society, I would say that's when Orthodox advocacy is at its very best, the combination of interests and values, and why I think we have a particularly powerful contribution to make in this line of cases.
And it's worth noting that if you listen to the recording or read the transcript of the argument, at one point, Justice Gorsuch was the one who touched on that point and asked, he was asking about, and he asked about some of the lawyers about, you know, will this impact some religions differently than others? He was asking it in the context of the state of Maine saying, well, you know, families could have their kids get their religious education at Sunday school. And I think the way Justice Gorsuch put it was something to the effect of, well, that might be sufficient for the Protestants, but it might not be sufficient for the Jews, for the Orthodox Jews. So, you know, we'll see how, if that kind of perspective comes out, maybe in some of the court's opinions as well.
Absolutely. First of all, very well said, Avi. That was very poignantly put. So I wanted to, unless Avi or Nathan, you had anything else that you wanted to add on a general matter, I wanted to dive into some questions because we have some really good ones. To start off, someone asked, are other religious groups pushing this via amicus briefs as well? Just sort of, could you speak to, I guess, the coalition of other faiths and organizations that are working on this?
Yeah, there's been a range of religious groups, as is often the case in these kinds of Supreme Court cases, frankly, on both sides, that you have what I would call progressive religious groups, Jewish and non-Jewish, filing amicus briefs in support of the state of Maine. You have groups ranging, you know, on our side, ranging from Aguda and Culpa to other groups like the Catholic Conference and various evangelical groups on both sides. If you're really interested, if you go to the SCOTUS blog website and you find the Carson versus Macon case page, they have links there to all the amicus briefs, and you can spend an inordinate amount of time, you know, leafing through them across the religious spectrum and beyond.
Got it. Okay, great. Another question here.
Maybe in this context, Dan, if you don't mind my just mentioning, I like to promote the Notre Dame Religious Liberty Clinic initially did work for the Orthodox Union at the cert stage when the Supreme Court was deciding whether or not to take the case, and the Orthodox Union joined with both Christian and Muslim schools in order to make this point. You know, when the case came now on the merits, you know, we thought it was important to give a particular Orthodox Jewish voice, kind of very specifically about halachic Judaism. But I'm grateful that the National Council of Young Israel joined with the Notre Dame Religious Liberty Clinic and other groups in order to kind of have this multi-faith or interfaith expression of why these cases are so important to faith communities in the United States.
Right. And another question that came in, what about a bill subsidizing private school textbooks? Would that include Chumashim, Mishneh Torah? And if not, what's the conceptual basis for the distinction?
I think I saw that question came from one of my favorite interlocutors, Joseph Kaplan, if I have that correct. So shout out to my favorite interlocutor. So, you know, in all of these cases, you have to start from the secular purpose or interest that the government has, right? Keep in mind, this is the government opens some program not to like fund religion. It has some sort of secular neutral goal. So, you know, you'd have to figure out what that goal was and then whether it covered Chumashim or the Mishneh Torah. It's a little hard to figure out how you would thread that needle. I mean, I could come up with some strange hypotheticals, but it is unlikely that you would have a secular and neutral government purpose in opening up a funding program for private institutions that would track those. Not impossible, but I would say extremely unlikely.
Here's another question. What risks might we open our schools to if the government would fund our secular studies program?
Um, um, you know, the old saying, right, is with government. There are actually folks in the evangelical Christian community that like to say, with government shekels come government shackles, and they definitely, you know, can put conditions on that come along with the funding, that could, you know, theoretically could include curriculum requirements. It could include non-discrimination requirements, and a range of other issues. Now, again, some of those issues, you know, the lawyers always have the next case. So, you know, some of those issues you would indeed be able to litigate further on. Okay, just because a religious school takes government funds, are you going to now say, and you required them to not be excluded, because to exclude them would be unconstitutionally discriminating against them? You know, does that, you know, then lead you to say, well, we're going to say you can't be discriminated against, but we're still going to impose conditions on you that would make you violate your religion? And if that's the case, isn't that discrimination also? Or are we going to say, no, part of also non-discrimination is allowing you to continue to practice your faith freely, certainly, I mean, within certain parameters, and not be interfered with? So just because you take the funds doesn't mean that, you know, if your policy in your shul or your school is we only hire Orthodox Jews, you know, in certainly in teaching positions, which, by the way, you know, is supported not only by the Federal Civil Rights Act, is also supported by something called the ministerial exception, which the Supreme Court upheld a few years ago in a unanimous decision, right? So there are constitutional protections against government interference, but you know, there might be things that are put in place that would potentially at least have to be further litigated.
Right. There are quite a few questions about the process and next steps. So for the uninformed, sort of, now that arguments were heard today, sort of what happens next, and do we have an expected timeline for when this case will be decided?
I mean, the process that we know from the outside is that, you know, if you've ever followed Supreme Court baseball, I guess, the justices gather in a conference room just amongst themselves with no staff, no clerks, and they talk about the case and take something of a straw poll kind of vote. And if the Chief Justice is in the likely majority, he gets to either decide he's going to write this opinion himself or assign it to another justice in the majority. If the Chief Justice is in the minority, then the most senior justice in the majority plays that role. Generally, these kinds of cases, which are sort of the more high profile, you know, front page of the New York Times, Wall Street Journal type cases, just to keep us all in suspense, the court holds on to till mid to late June, at the end of their term, when they release these kinds of opinions. So that's generally the time frame.
Got it. Okay, there's one question here, Avi, to your excellent synthesis of the prior cases that informed this one. They wanted to dive in a little bit deeper. Can you explain why the Espinoza case does not settle the question in this case?
Yeah, I mean, the reason is because the Supreme Court in Espinoza said they don't want to settle this issue. The majority opinion expressly said we'd like to dodge right now and just say the case of the Espinoza case, which dealt with a Montana kind of school scholarship program. Don't want to get into the details, but they said, no, this would be religious status discrimination, no matter how you look at it. So we don't have to address whether or not states can still exclude religious use. If kind of the point here is that the Supreme Court doesn't seem to be efficient in terms of its willingness to decide issues more quickly. I wholly concur and am hopeful that we don't end up with something similar in 2022.
Okay, here's a question that was also briefly touched on, but were there specific positions held on conservative versus liberal lines? And if so, what were they?
Well, certainly, I think in a certain sense, the most outspoken liberal justice on the, who was likely to support the state of Maine is Justice Breyer, who focused most of his comments and the arguments on, I would say like a classic explanation for separation of church and state, which is we want to protect our society against interreligious strife. We don't want us to have, we don't want America to have sort of the medieval European experience of, religious wars, and that has stood us in good stead. And aren't you opening the door for all that kind of strife if you start funding actual religious activity? Justices, although it's interesting, by the way, just to note that Breyer and Kagan were in the 7-2 majority in the Trinity Lutheran case, in the case that said you can't not give the grant for the playground refurbishing to the church. So maybe theoretically he's still gettable on a narrow opinion in this case, but I kind of, based on his comments today, I'm a little skeptical. I think Justice Kagan was a little bit more enigmatic in where she might land. She's probably not in the majority in this case, but again, that might depend on, are there some conservative justices that want to go in a more narrow direction, and maybe Kagan can be brought in if they make it narrow in a particular way. Hard to say. And I think I'll turn it over to Avi here. I think Kavanaugh, Gorsuch, Thomas, Alito, seem pretty clearly skeptical to the arguments that the Attorney General for Maine was making in various different ways. Mostly they called him out on trying to totally change what the state of Maine's program is and how it functions in his presentation today. And they kept calling him on that and saying, no, that's not how your program works. I think we know that, again, they're sort of more going to rule in favor of the plaintiffs, but we don't know how broadly. And the chief is always full of surprises. I think I'll just say that. But Avi, what were your thoughts?
Well, I wanted actually to think about the question from the perspective of not just the justices, but also kind of Jewish advocacy around the question. One of the fascinating things that's happened over in recent years is it used to be the 40s, 50s, 60s. There was nobody was more in favor of a strong separation of church and state than the American Jewish community. Rise of orthodoxy in the 60s and 70s and 80s that began to change a little bit. But in recent years, there have been some real changes as to how various American Jewish institutions view this. One thing that's happened within the Reform Jewish community is a willingness to begin taking security grants for houses of worship. That is very new, and in many ways, I think, can be tied to the trauma of Charlottesville. And kind of the danger that the Reform Shul was put in over there, and kind of the way that's trickled back as to if Jews are in real danger, maybe separation of church and state is fine, but not when it puts actual lives of Jews at risk. And I'd say kind of in the more narrow context that we're talking about here, funding of Jewish schools, parochial schools, the American Jewish Committee recently came out and said that it's reevaluating its opinion as to whether or not you could have government funding going to religious institutions. This is incredibly new. This is certainly not at all what the American Jewish Committee was saying, again, in the 50s and 60s and 70s, even more recently. And, you're beginning to see, I think, a way in which I would like to say certain kinds of Jewish interests, the importance of schooling, the importance of security, and also questions of, values. Do we have a right to the same kinds of funding that everybody else has? is starting to change the conversation as to how American Jews think about their place at the government table.
All right, we are now at 4:30, so I think that's all the time we have. I just wanted to end on highlighting one point that Nathan made, which I thought was very poignant, which is to say, this case does not mean that all of a sudden, every aspect of funding will automatically happen. It really does take a lot of hard work on the advocacy front, and it really relies on everybody on this call to get involved in OU advocacy, get involved in Teach Coalition, and ensure that, even if this case is, decided in the most broad way and the most favorable way for our community, there's plenty of work ahead of us to make sure that new funding streams and more assets and more services for our schools and shuls and other institutions actually comes into existence. So we rely on all of you for that. And we thank you for being on this call, for joining us. And we will obviously keep you in the loop on any updates that we have on this case as it goes on. So thank you so much. Thank you, Avi. Thank you, Nathan. Everyone have a great afternoon and evening.